Who provided him the suit? His parents? How'd he get the suit?
You'll remember one day. What's that?
Nor can his
attorneys.
shackles be photographed. So just quickly, I want to get your thoughts as we begin. And just quickly, we're taking a live picture here from the courtroom. That is, in fact, Tyler Robinson there, sitting there. And you see he is not in prison garb. He is in I believe, in a shirt. I can't tell if he has a tie on. It looks like he does have a tie on as well. Obviously well-groomed. Michelle, quickly.
Yeah, well, they're concerned about the impact on potential jurors. So they want to make sure, certainly, that Robinson's attorneys want to make sure that there's no bias against him if he's shown, be in prison-type garb and things of that nature. And so today's hearing is about whether they can restrict the media's coverage to prevent there being an undue influence on a potential jury pool.
Well, let's talk about that a little bit. This is one of those cases that has received widespread, probably one of the biggest national news stories in America for this particular year. And it's one of those cases that I think cries out for the public wanting to see this, perhaps even needing to see this based on our judicial system and some of the trust that's been lost over the last year or so. What are your thoughts on those arguments? Because basically the arguments are going to be exactly that. The judge has to weigh his rights to a fair trial versus the public's right to know.
That's exactly right. I mean, the judge is looking at, the public's right to know. This is obviously a matter that's garnered great attention across the country for obvious reasons. And so the public does have a right to know what is happening, and we need complete transparency within the judicial system. At the same time, the judge has to ensure that the defendant's rights are protected and that he gets a fair and impartial trial. Now, this is a case where, there's a lot of strong feelings in the court of public opinion on both sides. And so I do think that the judge is going to have a tough decision in deciding what limitations, if any, should be imposed upon the media, because this is such a great case of public interest.
Yeah, and Michelle, the defense makes the argument, this is a new day and age, and one of the things that they're arguing is that there has been a lot of misinformation in the media. When you look at certain things, certain social media, things of that nature, a lot of our news is sort of sent out or received in that fashion. And they point out that there have been pictures of him that have been AI generated or depict him in the wrong way. There have been tweets and various things and posts that put out a lot of misinformation. All that is a very serious concern to the defense, and obviously it's going to be to the judge. How might that play into her decision now?
Well, here's the thing, Michael. In this AI generation world that we're living in, I don't know that restricting the media's access and the public's right to know is actually going to solve the problem. There was a report that there was an AI-generated image where the defendant was crying in the courtroom during a prior proceeding. That was essentially false. Preventing the media from being a part of this proceeding doesn't really solve that problem. So I do think the court's going to consider the fact that certainly the more images that are put out there, more video of what's happening, the more likely there could be of doctored images of the defendant. But at the same time, I think the public's right to know may certainly cause concern about restricting the media too much, because I think the media should be part of the proceeding.
Yeah, all right. It looks like things are getting going. The judge has entered the courtroom. I'm not sure we have audio yet. Looks like there should be audio. Let's go live to the session.
Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff Hunt and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Good afternoon.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of media interveners also identified in the briefs.
Good afternoon. And I recognize Mr. Robinson in the courtroom as well. Good afternoon. And just for the benefit of the record, calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues.
Your Honor, Christopher
The
Ballard,
first
Ryan
is the
McBride,
October 14th,
Chad
2025
Grunander, and
audio
Lauren
recording
on behalf
of the closed hearing and the October 24th, 2025 transcript of that hearing. The second is the state's motion to amend or clarify the publicity order, commonly known or referred to as the gag order. And finally, the motion for limited intervention and request for notice of motions to close, seal, or reclassify, and which has been filed by the media organizations and by counsel who are present today. So as we begin, the first part is we'll begin by addressing the October 14th audio recording and the October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording, the record should remain sealed. All members of the public and the press will be excused, and the hearing will not be broadcast. This is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties, or the public and the media, to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother. And we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state. Will resume transmission.
My only concern with that, Your Honor, is that we're going to be talking about court security measures.
For limited intervention,
and
followed by the state's motion to amend or clarify.
I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing? To issue my ruling today.
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning
Thank you, Richard Novak, Mr. Robinson.
disclosure
Mr. Robinson has
of what is discussed in closed session, but obviously it's up to the court.
Thank you, Mr. Novak. We're going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it, I believe it is appropriate to treat all parties in the public equally, though I do recognize their relationship with Mr. Robinson. Thank you for your request. All right, we will go into the closed session. Thank you.
Those issues being discussed in public.
Mr. Novak, do you have authority?
All right, so you heard the judge there. There's three things that need to be addressed. The first one,
no, I think
the
it's
public is not
subject to the
allowed
court's
to
discretion
hear. It's going to
to
involve
decide
some
who
sensitive
is and is
issues,
not
issues that
appropriate
are actually being argued as to
member of
whether
the
they should be
public.
closed
I think they
from
have a
public
unique
dissemination
relationship
at
with
all.
Mr.
So obviously not
Robinson,
something
and
he would
they,
want publicized in
would
any way. So everyone being
abide
removed from the
by
room.
any
We're
orders
also going to
the
address
court
this issue of
makes
access going forward as far as the media and things of that nature as well. And then also there's going to be some issues with a previous order regarding publicity that he had made earlier. The state wants some clarification. They'll argue that as well. When they come back, we'll be able to show you 2 of the 3. So right now, we just have to stand by. I want to bring back in our guest still with us, trial and family law attorney Michelle Thomas. Michelle, there you saw. I mean, it makes sense. I mean, I'm not 100% sure of the issues that will be addressed, but some of them are regarding things that may or may not be allowed to be shown to the public in some sense, audio recordings and transcripts of a previous proceeding, as well as it sounds like security will be addressed as well. As you heard one of the attorneys there, the judge obviously has to keep us out, because if it's going to be something eventually he decides to keep from the public eye or public view, they can't have heard it at this particular hearing.
Right, that makes perfect sense. I mean, the court has to certainly protect and prioritize the defendant's rights to an impartial trial, and in so doing and making these pretrial motions rulings, he has to do so outside of the public, essentially, context in order to determine what should be admissible, what's not admissible. So apparently some things were said in this prior hearing that the lawyers are arguing about. So that was the right decision, certainly, for him to make that call.
And it seems like the defense is really trying very hard to keep this case closely guarded. Again, public sentiment really strong, I would imagine, overall, against Tyler Robinson, so one can understand. What do you make of them? I mean, it seems as though that's really job number 1 at this point, is to protect his privacy and, obviously, his right to a fair trial.
Right, and I think you hit the nail on the head, Michael, is that the reason his lawyers are fighting so hard is because the general, I think, public sentiment does not favor this defendant. So I think that they know sort of what the climate is. Certainly they've heard from the administration, our presidential administration, that's made comments about wanting the death penalty to be imposed here. So they have a really strong, I think, case for why they're fighting so hard to ensure the jury pool is not tainted going into this trial. That being said, the judge has to make sure that any restrictions that are imposed are narrowly tailored to address any potential harm, because the public does have a right to know what's happening in these proceedings, and we do want to ensure transparency and fairness in the proceedings. But that's the reason, essentially, they're fighting so hard.
Yeah, certainly not an easy decision for the judge, but he did say he will have a ruling today. So we'll be looking forward to that as well, coming up a little later in the hour. All right, stand by, Michelle. Folks, coming up, we're going to head back to New Hampshire for the sentencing of Dustin Duran. Again, he was convicted of killing his girlfriend, Caitlin. We're going to hear from Caitlin's stepfather when we come back. So keep it here on Court TV.
It was a
front row seat to justice.
This Christmas,
disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, will safety concerns trump public access in the Charlie Kirk assassination case? We'll bring you the latest developments from today's big hearing.
Closing Arguments tonight at 8/7 Central, only on Court TV. Tonight at 8/7 Central, only on Court TV.
Imagine being able to build anything just by thinking about it. Meet Base 44, a complete
Back now to New Hampshire, folks, where convicted killer Dustin Duren is being sentenced today in the Amber Alert murder trial. The 38-year-old father was found guilty earlier this year for fatally shooting his girlfriend, Caitlin Notziger, for kidnapping their two young children. Thanks to an Amber Alert, police eventually located Duren driving with his two young daughters, who were unharmed, thankfully. Let's get you back in the court now, where Caitlin's best friend, who is giving a victim impact statement to the court via web. Amber Alert. Duren driving with his two young
growing up, what's happened. It's horrible. Horrible. It's all it. It's so graphic. It's played one into once. What happened?
Never in my life was this statement I thought would be my truth. And now I painfully live with that fact.
And then we followed the process. We followed the manhunt, who he is, Ida Roberts, the person that did this,
but never thought I would have to worry about an unjustified, violent, intentional murder.
President of the United States is the one that announced the press. Early morning, a couple days later, we followed it through, we watched the plea come out, mom's house, a couple of weeks, stands free, videos.
An indescribable magic energy about Kirk that brought me a sense of belonging and purpose. Kayla called me her type, but in truth she was mine. I don't quite know how to exist without her, nor would I ever choose to another day. Kayla wasn't proficient with expressing herself through words, but through long conversations sitting on the couch, dancing, and simply living life together. Kayla was able to verbalize the things to be that she hadn't been able to previously. I am the one person who she shared everything with. I was proud enough, and it would be an honor to speak for her so that she could not. There's not enough space on these pages to list the inconsistencies, delusions, and straight-up lies that were told and inferred by Dustin and his attorneys during the trial. Instead of listing what I know to be true, from text messages and phone conversations with Caitlin, listening to conversations between Dustin and Caitlin, and my own attentive observations, will focus the broader scope of the impact of Dustin's actions and attempt to speak on behalf of my best friend, the dear Caitlin. Caitlin was dear to Dustin and felt trapped. There were several instances during their time in Nevada that Dustin became aggressive with Caitlin during arguments, and even as a toddler, Ellen tried intervening. When Caitlin and Justin decided it was time to leave Nevada due to finances and lack of family and friend support, Caitlin and the girls moved in with me in Minnesota. Caitlin did not want Dustin's parents to be alone with the girls and did not want Dustin to know the location of her safe haven with me. Caitlin shared with several of her closest loved ones in recent months before her death that if anything were to happen to her, she wanted the girls to be raised by her brother Bailey, her cousin Annie, or me, and in that order, as she said. We were all supporting each other to manage our separate households.
Wish you had a professional business address and phone number instead of your home address and personal number? Are you
Dustin's behaviors of control, delusions and paranoia, threats, and physical violence prior to his choice to kill the mother of his children are worth mentioning.
Good afternoon.
As far as I understand family law, Dustin had no legal rights to the children and been only resident of Minnesota and Nevada.
576, State of Utah versus Tyler James Robinson. For the prosecution and for their purposes.
Dr. Christopher Ballard and Chad Brunander on behalf of the state.
Your Honor, Captain Mr. Richard Nomad.
Seems to be the motivating factor in all of these unjust experiences. Caitlin had no intention and didn't even suggest that she would ever try to keep the girls from Dustin.
Mr. Robinson,
In reality, Dustin actually physically touched the
Mr.
girls from
Robinson,
Caitlin on countless occasions and became aggressive or violent when she tried to reason with him.
Good afternoon to you.
Caitlin reported one of these moments to
We're here on the
Minnesota
Tyler
police
James
where Dustin
Robinson
was staying with
motion.
his parents and the police did nothing. Dustin also bruised Caitlin's back with a physical assault in front of his father when she asked Dustin for financial support. Yet defense of Dustin's actions continued. During confrontations in Nevada, Ellen would stand between Dustin and Caitlin and scream at her dad. Ellen has since shared with me that she wasn't strong enough to protect her mom. Ellen's own thoughts and observations of why her daddy killed her mom is that he wanted the girls all to himself and he wanted mom gone. Dustin ruined his children's lives and Caitlin died protecting them. During the defense trial, Dustin showed no signs of remorse, regret, or compassion for killing the mother of his children, or how Caitlin's loved ones, including his own children, have been affected by it. Her long-winded defense proves that he still believes he was justified in committing murder. Unfortunately, my best friend's life ended as a perfect example of the importance of the support needed for mothers and women living with domestic violence. Sadly, I now believe that the murder of my best friend was an inevitable fate. Dustin was determined to control the situation, even if that meant she had to die. Dustin has not and will not learn to be a lawful man, human. He was determined to have the children to himself for God bless them, favoring moral decency over the law. He should never be allowed to live in a civilized society or have any rights to be active in his children's lives after the terror he has placed on all of us. It is impossible to state how the murder of my best friend has impacted my life because it has taken control of everything and continues to take control at any given moment. None of Caitlin's adult loved ones have even had a chance to focus on ourselves or deal with our own loss and grief or how it has impacted us fully, because we all have been focusing on the effect it's had on the girls and trying to ensure they are safe and cared for. The aggressive nature of Dustin's defense and his family's non-compassionate actions and words, even after an entire jury found Dustin guilty on all charges, continues to impact all of our lives. For me personally, there was the initial and immediate trauma effects of finding out what happened, trying to figure out what to do with myself and how to continue to resist. Everyone I lived with was suddenly gone and never coming back. I did not return to my home
Designer
for
writes,
weeks
designs,
after
and
murder.
formats your entire ebook in minutes. No ghostwriter, no designer. Hours after the shooting, so that media and commentators get speculated that the shooter was transgender. Because Kirk was a neuromancer.
About 6 months after speaking with investigators and the initial trauma started wearing off, I began experiencing frequent ocular migraines that caused me to have temporary blindness. gone to the emergency room at least 4 times for panic attacks since the murder, and now I'm forced to diligently work on managing the post-traumatic effects of the event. I took honored responsibility for Caitlin's and the girls' belongings after she was killed because they lived in my home. Due to the girls not being able to return to Minnesota for months after Caitlin was killed, I focused on sorting, packing, and distributing her treasured belongings. During these months, I spent long hours seeking information for the criminal case that only I might have. This is all I could do. As soon as the girls returned to Minnesota, I realized the new reality that my life was forced into. I could be there for them and start to help them have some familiarity, comfort, and a sense of their mom after the horrific events that they were forced to experience. Dustin's previous and continued actions have given me a new sense of fear and rage that it didn't exist prior to the murder. I now have to live with and manage daily, regardless of the results of this sentencing. And this countless days of work due to the trauma of the murder, the mental, emotional, and physical impact Caitlin's murder has had on myself has also affected all of my other relationships, my work, and every aspect of my life. Dustin's actions have absolutely impacted me financially as well, but money is the least important in the wave of his destruction. When Dustin chose to end Caitlin's life, he became not only a murderer, but also a thief. He stole dreams, futures, hope, joy, and love from everyone who loved Caitlin. Caitlin and I had a dream of a future shared home and life that I now have to live without. Dustin stole loving attachment and healthy development from his children. He replaced trust and love with terror and despair. Dustin not only ended Caitlin's life, he ended my life, his children's lives, and Caitlin's friends and family's lives. Anyone who loved Caitlin and saw a future with her was also killed when Dustin pulled that trigger. We are now forced to live lives and plan for futures that we did not choose. Our free will was murdered along with our dearly loved Caitlin. There's no justice in any of this.
Following Kirk's assassination, conspiracy theories emerged about the involvement of his.
If you're delivering to the U.S. and speed and local delivery matter most, go with U.S. Fulfillment. Orders are shipped from our L.A. facility. That means shorter.
Caitlin lost me, my soul sister and best friend, alive and dead. Caitlin and I decided that we would be each other's platonic life partners, and now I have to live without that. I ask that the court sentence Dustin the maximum amount possible for each individual charged. Even this maximum sentence will not accurately punish Dustin for his unlawful, whether charged or not charged, actions. Nor will it give us our lives and beloved Caitlin back, and may help us to find a new sense of hope for moral and just humanity in the future we are now forced to live. Thank you.
Thank you.
All right, so the victim's best friend laying out the myriad ways that this type of crime affects folks and different effects it can have on your life. Just really compelling stuff. All right, we're going to take a break. Coming up, we're going to bring you more from that sentencing hearing for convicted killer Dustin Durham. And again, we're keeping close watch on Utah for that motion hearing for Tyler Robinson. As soon as they come back from that closed session, we'll be allowed back in and we'll take you back into court. Keep it here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala. Let's head back now to New Hampshire for more of today's sentencing hearing for Dustin Duren. Duren was convicted back in October of murdering the mother of his children, Caitlin Knopfziger. Investigators say that Duren then took off with the couple's 2 children, prompting an Amber Alert. Let's head back into that courtroom now. Caitlin's sister-in-law, Heather Knopfziger, she's giving a victim impact statement. Again, this is via WebEx, so that's why we're not seeing them. Let's go back into court.
Your Honor, the next impact statement is also remote and is from Heather Knopfziger on behalf of herself, Caitlin's sister-in-law, and her brother.
Hello, Heather, H-E-A-T-H-E-R, Knopfziger, N-A-F-F-Z-I-G-E-R. My name is Heather, and I'm writing this statement jointly with my husband, Bailey. Caitlin Knopfziger was our sister and sister-in-law. We, along with many others, called her Goose. Goose was our light. She became the sister I never had and I always wanted. We enjoyed cooking together. And Goose would often come over to our house with the kids or by herself. Our home was her home. When she lived in Las Vegas, we would FaceTime with her and the kids often. We have always been a part of her and her girls' lives. I was there for the birth of Elowen and would help her often when she wasn't living out of state. Her dream was to live on a commune or within a co-housing system with her closest family and friends. She had so much love to give. All she wanted was for everyone to be together. They say with death that time can lessen the pain, or at least the initial shock. But the amount of pain we have endured is unfathomable. Even now, nearly 2 years since she's been gone, we remain devastated. We will never forget the exact moment we got that call at about 4 a.m. and that she had been killed. Bailey answered the phone, and I will never forget the gut-wrenching feeling I had. No, I couldn't hear anything except for Bailey's mom's hysteria. The phone call was short. He hung up and aggressively threw his phone across the room. The level of panic and rage on his face, and now mine, was like nothing we've ever experienced before. Nothing made sense. She was just at our house for dinner a few days before, telling us she was going to visit Elowen with Phelan. After that horrific phone call, we called all of our family members to come over to be with us. For weeks, we had every person in our lives come to our house to mourn the murder of our small, mighty Goose. That day will haunt us for the rest of our lives while we raise the girls. Dustin, we can speak for a minute when we say a big part of us all died that day. Since Dustin unremorsefully murdered our sister, we immediately started weekly individual therapy and eventually couple therapy. We found one of the top trauma therapists to see Elowen almost immediately after the event. Since day one, she has talked about the events of that day. She has replayed the rage on Dustin's face. And she would sometimes have hour-long episodes of uncontrollable rage and panic because she wasn't strong enough to protect her mom. She would pace the therapy office sounding like a wounded and dying animal. She even said to Goose's best friend Sarah that her dad just wanted them all to himself and wanted mom gone. There were and still are days when the panic and shock consumes us all. I had panic attacks often. I went on walks alone and cried until I was numb. I would sometimes fall to my knees. I'm pinching myself, wondering when this might ever end. It got so bad that I needed depression medication. There aren't words to describe how Bailey feels every day. Just like Goose always did, he finds solace in music, and I can't help but draw parallels to the song Growing Sideways by Noah Kahan. Bailey continues to move forward, though he has been running on empty ever since she was taken from us. In the time leading up to the trial and during the trial, we felt deep uncertainty about both the present and the future. In addition to our grief, we had new fears of our personal safety and for the safety of the girls. The public nature of the trial put us in a constant state of hypervigilance. Nothing could make me feel protected. Time will never heal our broken hearts. Our broken hearts, along with the broken hearts of our son, Emmett, and Caitlin's daughters, Evelyn and Valen, will always be clinging to the memory.
All right, we'll pause it right there. I want to bring back in our guest, still with us, child and family law attorney Michelle Thomas. And Michelle, first and foremost, I want to discuss what we're hearing so far from some of these victims. And the thing I want to point out is, I'm always amazed when we have victim impact statements, and people will talk about things that you never think about unless you've been in that position. For instance, the best friend talking about how it affected them emotionally, monetarily, and also, you know, this idea of what their future would be. They had plans and ideas of their future with this victim. All these things are devastating, and I think are really going to have an impact on this judge.
I think you're absolutely right, Michael. I mean, we heard from the aunt with a very sort of heart-wrenching narrative earlier when she said she will never create another memory with this victim ever again. And so it really does remind you of the humanity of the situation and how he has altered, this defendant has altered the lives of so many people, and for what? So senselessly. I think that's what the victim impact statements are conveying, that this was so unnecessary. And they really want him to feel the impact forever of what he has done and what he has taken from them. So I do think that they're making it very realistic and impactful for this judge, and that will be taken into consideration when he issues his sentence.
Now, you mentioned the 4 watt, right? The 4 watt was because there were issues between the two, particularly regarding perhaps payments in terms of child support, also custody of the children. You're a family law attorney. Time and time again in these cases, we see people that we know, people that seem to have decent reputations, become different people when they're involved in this type of situation. Talk to me a little bit about your experience and what happens to folks when they get involved in these family-type disputes.
You know, Michael, I tell clients all the time that the same person you married is not the same person you're divorcing. A lot of times you don't even recognize a person at the end of the day when you're in the midst of these, whether they're custody battles or divorces. People lose all sense of sensibilities. Their ability to reason and rationalize seems to be substantially compromised, and their emotions are just raging and in control instead of that person controlling their emotions and focusing on the best interests of the children.
Yeah, fair enough. Again, I don't think that's a mitigating factor, however. All right, Michelle, stand by. We're going to take a break. Coming up, we're going to bring you more from that sentencing hearing for convicted killer Dustin Doran. Also ahead, folks, we're still waiting. We'll take you back to Utah. Right now, the closed session is underway for that motion hearing for Tyler Robinson. As soon as that's over, the judge allows cameras back into that hearing. We're going to take you there live. So keep it here on Court TV, your front row seat to justice.
Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, will safety concerns trump public access in the Charlie Kirk assassination case? We'll bring you the latest developments from today's big hearing.
Closing Arguments tonight at 8, 7 Central, only on Court TV.
All right, folks, welcome back to Court TV Live. I'm Michael Ayala. Let's head back to New Hampshire now, where a sentencing hearing is underway this afternoon for Dustin Duren. Now, back in October, a jury found Duren guilty of murder in the shooting death of the mother of his children, Caitlin Nofziger. Now, after the fatal shooting, Duren set off an Amber Alert when he drove off with his 2 children. Thankfully, everyone was found unharmed. Let's head back into the courtroom now. We're continuing to hear a victim impact statement from Caitlin's sister-in-law, Heather. And again, she's speaking via WebEx, so you won't see her on camera, but we can hear what she has to say.
Caitlin, she loved fiercely, and her presence was always felt by those lucky enough to know her. She would come over to our house weekly to have family nights. Her goofy dancing would always bring a smile to our faces. Emmett would burst into happiness when he saw her, never wanted her to leave. Not even 2 weeks after she was murdered, we found out we were pregnant with our 2nd child. In fact, we found out when we flew to New Hampshire to be with the girls. Though our son Grayson has never met Goose, he will always know of his aunt, and he will see her and the girls as they all grow up together. Our family members always said Bailey was Goose's favorite and her hero. We did everything we could to support her. At times, she would ask for money as she was working at least 3 jobs and barely scraping by to provide for the girls, all the while Dustin was not working. She had said that if anything were to happen to us, she would want Bailey and me to care for her 2 girls. It was mentioned on several occasions to her closest loved ones that should anything happen to her, she would want 3 people to raise her girls in this order. Her brother Bailey, her cousin Annie, her best friend Sarah. Those of us she shared this with immediately took action after Dustin decided to take her life and started discussing options for the girls to honor Caitlin's wishes. Being her first choice, Bailey and I have honored his sister's wishes, and we are raising the girls on her behalf. We will cherish and take care of her girls as they were our own. This all became exponentially impactful as now our entire focus was on making sure the girls were okay, and we had to set our own needs aside of healing and grieving. A big part of us died with Caitlin that day, but that has only strengthened our commitment to grant her wish for us to raise her girls. We love you, Goose. And now we will take that love and compassion with us to parent your girls for the rest of our lives. Whatever Dustin is sentenced to will never compare to the loss we all feel or bring Goose back to us. Your Honor, we believe he should serve the maximum potential time. He showed no remorse or capability of it. Allowing him any leniency would only give him another opportunity to harm Elwyn, Valen, and our family. Additionally, Elwyn's therapist has requested that the child endangerment charges not be served concurrently with his other charges. As a 4-year-old, there is nothing else to do to stop the terrifying situation she was forced into. Perhaps when she is an adult and understands her family history more clearly, her therapist hopes she may feel that some justice was served for what was done to her personally. We ask that you please give special consideration to this request. Thank you.
Thank you.
All right, so that wraps up that victim impact statement. And just about every victim who has spoken in this case wants the maximum. And here's what's at stake. The defense is asking for 25 to life, which would be the minimum he could get. The state is asking for 45 to life, which would not necessarily be the maximum, but that's what they think is appropriate under the circumstances. The judge will ultimately make that decision. All right. Thanks to Michelle Thomas for joining me this past hour. We're going to take a break here. Coming up, we're going to bring you more from that sentencing hearing for convicted killer Dustin Duren. And also still, we're keeping a close watch on Utah for that motion hearing for Tyler Robinson. As soon as they come back from that closed session, we will take you there to live court. You'll be here on Court TV, the front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. Any moment now, that hearing for the suspect in the Charlie Kirk killing, Tyler Robinson, will resume. Right now, the hearing is happening behind closed doors. They are discussing the October audio recording and the transcript of that hearing. And remember, the shooting happened on the campus of Utah Valley University back in September of this year. Police launched a 33-hour manhunt for the shooter, Tyler Robinson. At least that's what they allege. That is until Robinson's family convinced him to turn himself in. Again, during that conversation, at least according to prosecutors and to law enforcement, he basically confessed to his family that he was the one responsible. I'm sure that would be a big deal in court. Let's bring in our guest. I would like to welcome back criminal defense attorney Joanna Nieves. Joanna, great to see you. Thank you so much for joining me here on the program. We have an important hearing, really the first time Tyler Robinson has appeared in court personally. He's appeared via WebEx or whatever they want to call it in that particular courtroom. But this time he's appearing in court, and per the judge's ruling, he's allowed to appear in street clothing. It seems this judge is inclined to really try as much as he can to protect his right to a fair trial, because that's what that ruling would definitely be about. And that's part of what this is about in terms of should we open up these particular hearings and, in fact, the whole case to the public. Your quick thoughts on that?
It's that the judge is going to be weighing two very clear interests: the public's right to access and, of course, the First Amendment and promotion of transparency and accountability, against the defendant's, the accused, right to a fair trial. This is a highly publicized, high-profile case that has, gained the interest of national political speakers and representatives. And right now, the defense is wanting to ensure that Mr. Robinson is not prejudiced by the high publicity that this has already garnered. On the other hand, this was a murder that took place in a very public space. And so, of course, the state and media are going to be arguing that this was already so public, the community and public maintains an interest in what happens with the prosecution going forward.
Yeah, I agree. And ultimately, this is such a big story. And this is not because I'm biased, because I'm in the media. But one of the things argued by the defense in terms of arguing for this thing not to be open to the media, in terms of that affecting his right to a fair trial, is that there's been a lot of misinformation. I think one of the best ways to avoid that type of thing or counteract that type of thing is to open this up, shine a light on what's going on in that courtroom, because then anyone who has misinformation, there's a record of what's actually going on.
I actually agree with you. I think that when you limit access to the public, then who is there to account for what actually took place? And I think the judge can find ways that are narrowly tailored that allow reporters to be in the courtroom. Maybe there's no live feed and live streaming of what's going on, but the reporters and media have access and are able to take notes and take, maybe even have delayed broadcasting about what's happening. But there is a measure of accountability and transparency that will be happening rather than a complete closure.
Yeah, fair enough. And what we've seen often in these Utah cases is there'll be sort of one camera that's a pool camera, provides information to everyone, provides video to everyone, and then one reporter who acts in the same way, which I think sort of balances both of those issues well. All right, Joanna, stand by. I want to take us back now to New Hampshire, folks, where convicted killer Dustin Duren, he's being sentenced today in the Amber Alert murder trial. The 38-year-old father was found guilty earlier this year for fatally shooting his girlfriend, Caitlin Nofziger, before kidnapping their two young children. Now, thanks to an Amber Alert, police eventually located Duren driving with his two young daughters who were unharmed. But Duren took the stand during the trial where he claimed that he shot in self-defense after Nofziger threatened to kidnap the kids unless he agreed to pay her money, which he didn't have. All right, let's get back into court now, where Caitlin's stepfather, Tim Smith, is about to give his impact statement to the court.
Honorable Judge Jonathan Frizzell, my name is Tim Smith, T-I-M-S-M-I-T-H. Judge Frizzell, Caitlin is my stepdaughter. She was taken from us, her family, by the defendant, Dustin Duren, on February 29th, 2024, Leap Day. I echo all the sentiments already voiced by family and friends, and thank you in advance for your consideration in this matter. When I think of Caitlin, the first thought that crosses my mind is, where would she be today, now? Caitlin was just starting to get her life figured out and set her course. She would have no doubt impressed us all with all her unique journey in her life, which was cut short and ended by the defendant, Dustin Duren, executing her. I'm going to be respectful of your time, Judge Frizzell, and let's get right to the matter at hand. The sentencing of Dustin Duren, who has been found guilty by a jury of his peers of the crime of murder and other aggravating, despicable crimes. Due to the heinous nature of the crime of murder that Dustin Duren has been convicted of committing, I implore you, sir, to impose the maximum possible sentence and that you make an upward departure in this sentence due to the following factors. Dustin has shown no remorse and lacks any sense of empathy for anybody impacted by his actions other than himself, including his children, which speaks to his narcissism. Dustin stole the innocence of childhood from the very people he professed to love and cherish. He and Caitlin's children, Elwyn and Valen. He murdered their mother in their presence. Dustin made a conscious and deliberate choice to execute Caitlin while she held their daughter, Elwyn. Elwyn will never forget what she witnessed, the murder of her mother at the tender age of 4 years old. Dustin adamantly believes that he is justified to murder when he doesn't get his way. The murder of Caitlin culminated years of classic textbook domestic violence. Isolate from family and established support systems. Move to Las Vegas and New Hampshire. Dominate, intimidate, control. When the control that Dustin imposed on Caitlin, which was facilitated by using their children as pawns, was lost, he knew he had lost control because Caitlin told him so. Like so many abusers, Dustin resorted to murder in a vicious attempt to maintain that control at all costs. I don't give my opinion on this matter, sir. I speak from 30-plus years of law enforcement experience in which I have and continue to serve in a maximum security facility and deal with all varieties of offenders on a daily basis. It's a violent, hostile environment, and I have witnessed numerous suicides. It hasn't made me a murderer. In closing, I would like to take this opportunity to thank the members of the jury for their service and all the good people in New Hampshire. Numerous citizens of this fine state have shown love, support, and compassion to my wife, my grandchildren, and our entire family, and we are forever grateful and appreciative for the support. And may God bless them all, including you, Your Honor, and all the law enforcement personnel that did their jobs. Dustin, there are laws, spiritual laws. I had to do the hardest thing in my life. When I found out that you had executed my stepdaughter, Caitlin, I immediately forgave you, had to. Hardest thing I ever did. For selfish reasons, because the Lord says, if you don't forgive, you will not be forgiven. But I do, sir, truly forgive you. Criminal law. You committed murder. You must pay a severe penalty. One law does not negate the other. And in doing so, I hope you do that with honor. Serve your sentence, whatever is handed down today. Do it with honor, because it's shown through, any of your therapists can tell you, if a parent would commit suicide, their children are apt to do the same. Don't put that on your children. Restore your honor, serve your sentence. Help others. May justice be served, and I will thank you in advance, Judge Frizzell, for ensuring that justice is, in fact, served. Thank you, sir, and thank the people of New Hampshire. May God bless you.
All right, we'll step aside here, folks, take a break. We'll have more on the sentencing hearing for Dustin Duren coming up. Plus, we have an update out of Massachusetts where the trial against Brian Walsh is coming to an end. Stay with us here on your front row seat to justice.
The disappearance of mother Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
Mr. Walsh was suspecting his wife of having an affair.
The massive trail of evidence.
This incredible timeline of Google searches.
It shows everything that was in his mind.
He searched how long before a body starts to smell.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Mic check. Mic check. Oh, we got something. All right, I think we're back in business.
Folks, let's turn quickly to Massachusetts, where the murder trial against Brian Walsh is coming to a close. Attorneys are expected to give their closing arguments tomorrow, beginning in the morning. Now, Walsh stands accused of killing and dismembering his wife, Anna, back on New Year's Eve day in 2023. Now, he told the court just earlier today that he will not be testifying in his own defense.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Now, no other defense witnesses were called, so the judge sent the jury home for the day. The attorneys, they worked to finalize jury instructions. Again, we will bring you closing arguments in the Brian Walsh murder trial tomorrow morning, right here, of course, on TV. All right, we're going to head back now to New Hampshire, where convicted killer Dustin Duren is being sentenced today in the Amber Alert murder trial. The 38-year-old father was found guilty earlier this year for fatally shooting his girlfriend, Caitlin Knopfziger, before kidnapping their two young children. We just heard several impact statements from friends and family of Dustin Duren. I want to get back into court now, where the defense is actually speaking to the court.
This is a tragic case, and no sentence that the court can impose will undo this tragic situation or make Ms. Knopfziger's family whole. The court has a difficult task in imposing sentence and in balancing the aims of sentencing. As the court undertakes that difficult task, we ask the court to consider Mr. Duren's history and background, his service to our country, and how that service forever changed him. And we also ask that the court consider the particular circumstances and context of this case. Mr. Duren is respectfully requesting that the court impose a sentence of 25 years to life at the New Hampshire State Prison on one count of second-degree murder, with additional suspended time on the reckless conduct and endangering counts. We ask that the court authorize that Mr. Duren can receive earned time reductions for completion of programming at the prison, and we further ask that Mr. Duren be ordered to comply with any Minnesota family court orders regarding contact with his daughters. As we discuss why the court should adopt our proposed sentence, I'm going to try not to rehash what's in our sentencing memorandum. We'll start by first talking about the aims of sentencing. We'll then talk a little bit about Mr. Duren as a person. I'll address some of the points made in the state's sentencing memo and in his argument today. Several of Mr. Duren's friends and family will address the court, and Attorney Kinney will read statements from some friends and family who are not here.
We're having a good Thursday.
We'll conclude by talking a little bit about the United States Supreme Court case, Porter versus McCollum. Starting first with the aims of sentencing. The defense's proposal balances the aims of sentencing: punishment, deterrence, and rehabilitation. 25 years in prison is punishment. It is decades of incarceration, decades without freedom or autonomy. It is a serious punishment for a serious crime. If the court imposes Mr. Duren's requested sentence, he will first be eligible for parole right around his 62nd birthday. He will miss his daughters' entire childhoods. He will miss their high school graduations, their college graduations, and their first jobs. He will not be present for many of the major milestones of their lives. He will not have the opportunity to spend time with his parents in their retirement, and he will miss the childhoods of his nieces and nephews. 25 years in prison will punish Mr. Duren for the crime for which he has been convicted, and it will forever change his life, but it will allow for a possibility of redemption, for a possibility of parole. If the court imposed the state's recommended sentence, Mr. Duren would not be eligible for parole until he was about 82 years old. This is a de facto life sentence. The Social Security Administration publishes actuarial life
Okay,
tables,
are we back in business
which
now?
provides statistical analysis of the average remaining number of years expected prior to death for a person. According to the Social Security's actuarial life tables, if the state's recommended sentence is imposed, we should expect that Mr. Duren will die in prison. The state's proposal is a de facto life sentence. And if the legislature was of the opinion that all murder cases should result in life imprisonment, it would dictate mandatory life sentences for second-degree murder like it has for first-degree murder. The legislature has not imposed such a sentencing structure for second-degree murder cases, and there is no requirement that this court impose a sentence that functions as a life sentence, and this court should not impose a sentence that functions as a life sentence. I understand that the state attempted to do some different calculations related to parole dates, but I think that those dates that the state provided obfuscate the reality. The reality is that Mr. Duren will not be eligible to earn the maximum amount of time off at the prison, because many of the ways that you earn time off at the prison are for completing, getting a GED, getting an associate's degree, getting certain certificates in education. And Mr. Duren already has those certificates. He's graduated from high school. He's a decorated military veteran. He has an associate's degree and other certificates in his field. And so he won't be eligible to earn that amount of time off. I also think the state's reliance on 651.20 to argue about the length of sentence, the sentence that Mr. Duren would serve, is not reliable. 651.20 is extraordinarily unlikely, extraordinarily rare, especially in a case of this type, and the state is not offering to not object to any such reduction in sentence. We have advised Mr. Duren, and Mr. Duren can expect, and this court can expect, that these numbers mean what they say, that 25 years is 25 years, that 45 years is dying in prison. And 25 years, Judge, as the sentencing comparisons show, allow the aim of sentencing to be, of punishment to be met. Turning next to deterrence. By ensuring that Mr. Duren has an additional suspended prison sentence hanging over his head, and that if he is paroled, he will be on parole for the rest of his life, this sentence will deter Mr. Duren from committing crimes in the future. He will know that if he commits a crime, he will be in prison longer or go back to prison. And this sentence will also act as a general deterrent for society at large. The message that Mr. Duren's proposed sentence sends is that if you are convicted of murder, you will spend decades in prison. That's general deterrence. In terms of rehabilitation, as I've said, the state's sentence calls for Mr. Duren to die in prison. That is not a sentence that allows for or supports rehabilitation. It is not a sentence that allows Mr. Duren to engage meaningfully with the rehabilitative programming that the prison has to offer with the aim of rehabilitating himself for his release. In contrast, the defense's proposed sentence furthers the goals of rehabilitation in two major ways. First, it allows him to earn some small amount of time off of his sentence by engaging in programming at the prison and by working to rehabilitate himself at the prison. And second, It furthers the aims of rehabilitation by allowing him hope. Hope that he will have some period of his life outside of the prison. Hope that he will be able to be reunited with his family outside the prison walls. Hope that if he works hard to rehabilitate himself, that hard work and that rehabilitation will pay off, and that he ought to take the time at the prison seriously because there's a chance for him to experience life afterwards. The defense's proposed sentence meets the aims of sentencing in this particular case. Turning now to Mr. Duren himself. The court heard from Mr. Duren at trial and had the opportunity to review our sentencing memo and its attachments, including statements from some of Mr. Duren's loved ones. And what I hope those materials make clear is that Mr. Duren loves his children more than anything. His friends and family all reference, and I think both his initial statements to police and his testimony at trial both demonstrate that he is an incredibly loving father, that his children mean everything to him, and that his life forever changed and he gained purpose when he became a father. I'm going to play for the court a piece of music that Mr. Duren composed that reflects his unyielding love for his children. Mr. Duren is a musician, a composer, and an audio engineer. And for most of his life, Mr. Duren has felt that words have failed him, and he's preferred to express himself through music. He feels that music is the language of the soul, and he wrote a piece of orchestral music in 2021 about his feelings during Ms. Nafziger's pregnancy, the birth of their first child, and the first year of Elwyn's life. This piece of music, which is entitled First Morning, is a tribute to the love that he feels for his family. It's Exhibit A in case lines, Judge.
Excuse me, Attorney Kettles, before you begin, my understanding.
All right, as I get set to play that, let's bring in our guest still with us, criminal defense attorney Joanna Nieves. And Joanna, you hear sort of the gist of the argument there. The one I want to discuss is this idea that if the judge follows the state's recommendation of 45 years to life, we're talking about basically a life sentence for a second-degree murder conviction, which is not something that obviously the legislature would have considered, or that wasn't the idea behind that aspect of it. They say 25 to life is better, gives them a chance. It establishes the punishment, the deterrence, and then rehab, opportunity to rehab, but also gives them a chance for a life afterwards. What do you make of that argument?
I think that what they're trying to do is set this up so that the judge probably falls someplace in the middle. I mean, there are some very significant aggravating factors that the state has already raised in terms of like the fact that this happened in front of the children and, the violent nature of the act. And, we are going to hear about his military service and, any mental health impairments or conditions he may have, but that might also be offset by the way he used his military service and training to carry out the crime, and how he relied on the fact that his training as a marksman is kind of this instinctual act that he followed in killing Caitlin. So I think that what we're going to see is probably something a little higher than 25. I don't know that the court's going to go with what the state has requested, though.
This is an interesting situation for the judge because there's also this charge of child endangerment, which under the circumstances can be added on to any sentence. When I think about this crime, the fact that they had, as far as I'm concerned, the audacity to argue that he loves his children. You don't love your children when you shoot their mother and you shoot her in front of a child. That's not about the children, that's about you, as far as I'm concerned. But at the end of the day, he can add on that child endangerment to whatever sentence he imposes. I think this is the kind of case that warrants exactly that. Your thoughts?
Yes, he can add it on. It can be consecutive to the second-degree murder conviction. And I do think that the defense is just trying to play out and for the judge the considerations that were going through her client's mind at the time, right? Like, I love my kids. I want to be with my kids. I've got to protect my kids. And that's what they posture during the trial. And so you see that kind of remanifesting here at sentencing. But I don't disagree that this is traumatizing for a child to, have seen this, remember it, even reenact it. According to one of the victim impact statements, the child has talked about what happened in front of her. And I think that that is really going to be impactful for the court when considering what to do.
Yeah, again, all those other mitigating factors taken into account, the way he did it still creates real serious considerations for this judge. All right, Joanna, stand by. We're going to take a break here. When we come back, we'll have more sentencing, more of that sentencing hearing for Dustin Duren. So keep it here on Court TV, your front row seat to justice.
There was one more cut left, or half a cut. I'll still make some more though. Did you pay the car insurance or no? This is a cancellation thing. Might be canceled for good. It's the 10th. Know how long this is been. This is been for cancellation. Let's see what it says. It says cancellation date the 12th.
Welcome back to Court TV Live. I'm Michael Ayala. Let's head back now to New Hampshire for more of today's sentencing hearing for Dustin Duren. Duren was convicted back in October of murdering the mother of his children, Caitlin Knopfziger. And investigators say that Duren then took off with the couple's 2 children, prompting an Amber Alert. Let's head back into the courtroom now. The defense attorney is addressing the court and asking the judge for leniency.
Report that details Mr. Duren's military service and why it calls for leniency in sentencing. We've also submitted a report from Dr. Pittman that offers an opinion on the way that Mr. Duren's service-connected PTSD impacted his actions and his decision-making on February 29th of 2024. When the court imposes sentence, we ask the court to keep in mind that Mr. Duren, at a very young age, stood up and volunteered to serve his country, that he served his country with honor and distinction, including service in Iraq, and that he will forever bear the psychological scars that his military service caused. The Veterans Administration has found that Mr. Duren has an 80% disability rating, meaning that he was 80% disabled as a result of his military service, and 70% total of which is from his service-connected PTSD. And I won't go into too much more detail about his military service because it is covered in the military mitigation report that we submitted. The next slide that I'm showing to the court shows photographs of Mr. Duren at various stages in his life with a number of friends and colleagues. Several of these photos show Mr. Duren at the Hollywood American Legion, where he worked as an events technician and an audio engineer. While employed there, Mr. Duren hosted a charity event for Battle Buddies, one of just numerous ways in which he was connected with veterans service organizations after his honorable discharge from the Marines. Other photos on this slide show Mr. Duren performing, and the group photo at the bottom left is from Merging Vets and Players, a nonprofit veteran support organization with which Mr. Duren was extensively involved. The next couple of slides, Judge, show Mr. Duren in the role that he loves most, his role as a father. And this exhibit ends with a photo of Mr. Duren. We are all more than the worst thing that we have ever done. We are all more than one day and one action. In imposing a sentence, we ask the court to consider Mr. Duren as a whole person, a person who is capable of redemption and rehabilitation. Turning to the state's sentencing memorandum and sentencing comparisons. The state attempted to characterize the events in this case in a certain way in its sentencing memorandum, to insist that Mr. Duren acted out of anger or control. We don't agree with the state's interpretation of why this happened. The court heard Mr. Duren's testimony, that Mr. Duren reacted when he heard his child scream, and the court should credit that testimony. We acknowledge that the jury found that Mr. Duren's actions were not justified under the law, but that does not mean that the state's assertions about Mr. Duren's motives or mental state are true. They are not. We ask that the court consider the context of this case, the context that led to the court instructing the jury on defense of others when imposing sentence. We also ask that the court consider the connection between Mr. Duren's PTSD and the events of this case. The state said in its memo that there is no connection between Mr. Duren's PTSD and this case. And I think they said in their argument that he didn't rely on PTSD at trial, and so the court can't rely on it now. But that statement is incorrect and it's wrong, and I think, again, it doesn't cover the reality of why and how we ended up presenting the evidence that we did at trial. There was extensive pretrial litigation that the state initiated focused on the admissibility of Dr. Pittman's testimony at trial. And the rulings that the court made have an impact in how someone chooses to go forward. I think the state's argument that because we didn't rely on or explain the connection between PTSD and the events of this case at trial is legally incorrect. It's burden shifting. It's punishing Mr. Duren for exercising his constitutional rights. And the state fought hard to prevent us from presenting Dr. Pittman's testimony. And so it cannot and should not use the fact that we were unable to present Dr. Pittman's full testimony against Mr. Duren now. The court can and should consider Dr. Pittman's testimony, I apologize, his expert report when determining what sentence to impose. That report has been submitted with our sentencing memorandum. There's an opinion from an expert, a highly trained and qualified doctor, himself a veteran, who works at Harvard Medical Center and Mass General, that outlines the links between Mr. Duren's PTSD and this case. And the court can and should consider this as extensive mitigation information when imposing sentence.
All right, let's bring back in our guest with us, criminal defense attorney Joanna Nieves. Joanna, interesting dilemma there for the judge. As you mentioned earlier, part of when he testified in front of the jury and the judge, he used his military service as part of a justification that it sort of, again, as you said, moved him into this instinctual space. We also did hear a little bit about PTSD, although you just heard the argument, and this in fact happened. They were precluded from bringing in an expert to talk about what role PTSD might have played in this crime. So the question for you is, they're asking the judge to consider it now. The judge heard his testimony. His testimony was rejected by the jury. Does the judge consider all that now?
Yes, absolutely. Any mental health impairment that he might have or any diagnosis can come in for the judge's consideration. It's not testimony that the jury got to hear, but we can't shy away from or pretend that the fact that he is diagnosed with PTSD and has an 80% disability, that doesn't exist. And so the judge will be able to see that. How much credence and reliance he puts on that is up to his discretion. I think what we're really going to, in my opinion, what the judge will really be focused in on is remorse. Where is that in the arguments that the defense is making right now? Are we going to hear more about that? Because we've heard about the military experience and the PTSD in layers, and he's going to read the reports. But one thing we haven't heard about yet is, where does Duren stand on his remorse?
And where does that remorse come from, right? Because one of the things that was argued by a number of the victims was that his aggressive defense, claiming that the children were going to be kidnapped by the victim, and that's what spurred him to act, really affected them negatively. The fact that he hasn't taken, at least in their eyes, full responsibility for this. Does he, in fact, now need to get up and say something to that effect? I think there's a space where he could make a statement and be remorseful without backtracking on whatever his defense was, because I guess appeals are still a concern for him as well.
Of course, and I really think it boils down on self-reflection. There is a space where these victims, the victim impact statements, although they don't determine sentencing, it talks about the harm that people have experienced and the impact that it's had on the community and the community interest in what happens. And a defendant can take that into consideration and say, you know what, now I understand how my actions have impacted others and impacted my children, and this happened in front of my child. And even though I love my children, here is the long-lasting impacts that can occur because of it. And that's not what I intended. I had a different intent. This was my understanding, my perspective and perception of the situation and how I acted. But I'm sorry for all the people that I've hurt. And I think it would really humanize him if we heard something like that come from him.
All right, we'll continue to watch and see if we do hear from Dustin Duren. All right, Joanna, stand by. We're going to take a break. When we come back, we're going to bring you more from that sentencing hearing for that convicted killer, Dustin Duren. And also, folks, do not forget, we're also keeping a close watch on Utah in that motion hearing for Tyler Robinson. As soon as they come back from that closed portion of that hearing, we're going to take you back into court. Keep it here. We'll be right back.
Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, will safety concerns trump public access in the Charlie Kirk assassination case? We'll bring you the latest developments from today's big hearing.
Closing Arguments tonight at 8/7 Central, only on Court TV.
How's everybody's Thursday going? We are still waiting. Heck, the rate they're going, by the time they get back, it's going to be the end of the day. Everybody come on in, grab some coffee, popcorn. Hopefully we'll get back to it soon. Let us know if you got any questions. Okay, excuse me.
Back to court in just a minute, but first an update out of Ohio in the drowned wife murder trial. Defendant Paul Hicks is accused of rendering his wife, Regina Hicks, unconscious before putting her into a car and drowning her nearly 25 years ago. Earlier today, the jury heard from Roger Whitestone, who recalled the day he and his father discovered the victim's car in a nearby pond.
Well, you knew it was a car when you pulled it up to the bank, is that right?
No, I was in the truck. I was driving, it was over the bank. Dad was, my strap was 30 feet plus my chains. I was almost up by the road, or the driveway when I was pulling, so I couldn't see. And my dad started having a heart attack, and so I went back there and, yeah.
Okay. But when you joined your father, did you realize?
Oh, yeah, it was obvious.
Okay.
Trunk lid was open, and it was obviously a car.
Okay. Did anything come out of the trunk?
Yeah. There's clothes, like, there was a bunch of stuff floating in the pond, I almost say clothes. It looked like somebody went shopping.
We'll continue to bring you updates on that trial throughout the day. All right, we're going to head back to New Hampshire now, folks, where a sentencing hearing is underway this afternoon for Dustin Duren. Now, back in October, a jury found Duren guilty of murder in the shooting death of the mother of his children, Caitlin Naufziger. Now, after the fatal shooting, Duren set off an Amber Alert when he drove off with their 2 kids. So let's head back into the courtroom now, where Duren's defense attorney is making a case for leniency.
Finally, the state claims that Mr. Duren has shown no remorse and has not demonstrated responsibility for his actions, and we would contest that claim as well. A decision to exercise one's constitutional right to go to trial is not a lack of remorse or responsibility, and a person should not be punished for exercising their constitutional rights, including their right to go to trial and to hold the state to its burden of proof. And contrary to the state's assertions, Mr. Duren is deeply remorseful that Caitlin is dead. He testified about how horrible he felt at trial, and you will hear from witnesses who discuss Mr. Duren's devastation that this has occurred. Mr. Duren has never denied that he killed Miss Naufziger. He called his parents and told them, knowing that they would call the police. He waived his Miranda rights and told the police what had happened. He testified at trial about what had happened. He has never denied what has happened. He is devastated and horrified. Turning to sentence comparisons, as both sides have acknowledged, every case is different, every person is different. Both sides can point to cases where the sentences imposed were similar to the sentences that they are requesting in this case, or try to distinguish this case from sentencing comparisons that were provided. With those caveats, I'm not going to go through the state's sentencing comparisons one by one and explain how they're different. I think you can see that in the state sentencing memorandum. But I do just want to note for the court that there are some reasons that the sentence that Jesse Sullivan received is not an appropriate sentence for the court to consider. And Attorney Kinney and I have ethical obligations that prevent us from saying more, but Attorney Duran represented the state on the case and is aware of the irregularity in that case and how that particular sentence was reached. I'd also like to highlight 2 of the cases in our memo, Tyrese Harris and Dylan Sleeper. Both are cases in which the jury was instructed on both self-defense and manslaughter, but ultimately the defendant was convicted of second-degree murder. Neither of those defendants was a veteran with service-connected PTSD. Service-connected PTSD that an expert has opined played a role in the events of that evening. Mr. Sleeper had a prior criminal record, unlike Mr. Duren, who has no criminal record. And both the Harris and Sleeper cases are cases in which the defendant was sentenced to 25 years to life after trial. The sentences that those defendants received are the same as the sentence we asked the court to impose, and they demonstrate that the sentence the defense is requesting is a proportionate sentence in a case of this type. Judge, we'd like to give the opportunity for some of Dustin's friends and family the opportunity to speak. We submitted multiple letters along with our sentencing memo, and there are additional letters we've received since submitting our sentencing memo that have been uploaded to case lines. Attorney Kinney will read those letters, but I'd also ask that the court accept as exhibits all of the documents and materials that have been filed in case lines for this hearing, just for the purposes of making sure we have a complete and accurate record.
Your Honor, may we approach?
Certainly.
All right, so now it looks like they're going to read onto the record some letters that they want the judge to hear. Let's bring in criminal defense attorney Joanna Nieves. Joanna, we're at the point now where the judge is ultimately going to have to make a decision. I do want to point out one thing. One of the arguments made by the state regarding that 25-year to life recommendation by the defense is that he would be eligible for parole under the rules in 11 years. What the defense argued was the things that would make him eligible in that short amount of period of time are not really available to him. Things like getting a GED, things that, he's already got those things. So it doesn't, the time that they're talking about doesn't really apply here. Is that something the judge is going to consider?
I don't necessarily think that it'll hold much weight in terms of the totality of what the judge is considering. I think it is a factor that, there is this misalignment in the sentencing credits that could be applied and how soon he may be able to be eligible for parole. But I think in the grand scheme of things, we're talking big numbers. And I think that the judge is going to impose a sentence that is above the 25 to life range that they're asking for. One of the things that she touched on was like these other cases that where the sentence imposed was 25 to life, and they had far more, egregious criminal histories or far more egregious circumstances. However, my question would be whether or not there were children involved who were actually witnesses and endangered by the crime.
Exactly. Whether that circumstances more egregious, I think these were pretty egregious to and of themselves. All right, Joanna Nieves, thank you so much for joining me this hour. Truly appreciate it. Folks, stick around because coming up next, Judge Ashley Wilcott will be joining me for more of that sentencing hearing for Dustin Duren. So stay with us. We'll be right back here on Court TV.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we are in New Hampshire, where convicted killer Dustin Duren is being sentenced today in the Amber Alert murder trial.
The 38-year-old father was found guilty just earlier this year for fatally shooting his girlfriend, Caitlin Nafziger, before kidnapping their 2 young children.
Thanks to an Amber Alert, police eventually located Duren driving with his 2 young daughters who were unharmed.
But Duren took the stand during the trial where he claimed he shot in self-defense after Nafziger threatened to kidnap the kids unless he agreed to pay her money that he didn't have.
Now, earlier today, we heard from family and friends of Caitlin, the victim in this case. Now we're going to hear from Duren's relatives. I want to get you back into court, where his cousin Susan Chin is speaking to the court.
Chin, and I am Dustin Duren's cousin. I have known Dustin my entire life, that being 37 years. I would consider Dustin to be one of my closest cousins. Dustin and I grew up camping together with our families, attending holiday events together, and as adults, meeting up whenever I was in Las Vegas so our children could play together and we could catch up. I am aware of the crime that Dustin has committed. Dustin was raised to be a very well-rounded and respectful person. Dustin is extremely intelligent, a very kind and loving person, a hard worker who followed his dreams, and over everything is an amazing, loving, and caring father. Dustin followed his dreams out to Las Vegas. Once Dustin became a father, being a father was absolutely everything he wanted and needed in his life. Dustin was someone you could call whenever you needed advice, to be picked up, cheered up, or just a little motivation. Dustin did everything in his life to provide the absolute best life for his daughters. Dustin's sentencing would greatly impact his relationship with his daughters and also our family dynamic. We cannot fathom living the rest of our lives not being able to see him be the amazing father that he has been to those girls. It would also devastate our family to not be able to spend holidays with him or vacations with him ever again. It would be detrimental to our family if he was sentenced harshly. We pray that you can sympathize with Dustin and his family during this extremely difficult time. We are asking for leniency, so someday Dustin and his beautiful daughters will be reunited, and he will be granted another chance to be their everything. To be able to give Dustin the opportunity to see his girls graduate high school, go to prom, graduate college, get married, and hopefully one day be a grandfather to their babies would be the ultimate blessing for not only Dustin, but our entire family. We all want nothing more than to see that happen. I appreciate your time reading this, and I am willing to give you more information about my relationship with Dustin or his character. Please feel free to reach out to me at any time with any questions. Thank you so much.
Thank you.
Dear Honorable Judge Frizzell, I am writing this letter for leniency regarding Dustin Duren. My name is Devin Gomez, and I served with Dustin in the United States Marine Corps from 2005 to 2009. Upon hearing what a heinous crime he had committed, I could scarcely believe the charges. Second-degree murder of his significant other, Caitlin Nafziger. What a horrible shame, I thought. This hardly seems becoming of the honorable, humble, humorous, and happy Marine Iraqi war veteran that I knew and so proudly served with. To my dismay and disbelief through watching the trial, I sunk to find that the unfathomable news was in fact confirmed. This troubles me deeply because Duren was an exemplary figure to look up to and work with while serving. Always great with mentoring, first to lend a hand and lead by example, talented with a gift for music that he would often demonstrate at gatherings that would uplift his comrades. He continued living an honorable life, clean record, loving family, till he was nearly 40. Then one inexcusable and dreadful moment will lead to the ruin of an otherwise distinguished and well-to-do man. I believe if this dreadful occurrence could happen to Dustin, then it could happen to anybody. It pains me that this one moment of darkness and mental deterioration will lead to a long, if not life imprisonment for my good friend and otherwise good man. Yet I know that to take a life is truly the most evil and justifiably punishable crimes, even though in the Marines, command encouraged us to be ready killers should the need to defend our country and those we love should arise. Punishment should be handed to anyone who recklessly takes the life of another. But is justice an eye for an eye? Does it require to take his life through imprisonment to justify the life he took? This takes somebody of high regard and honorable motives such as yourself to decide upon sentencing. I personally believe that to rot in prison is a far worse punishment than death. I also believe that given the chance and hope that there will be time to reconcile after punishment, Dustin would be able to spend much remaining time helping and inspiring those around him as he did in his first 38 years of life. I hope that there is a small chance of a lighter sentence for Dustin Duren. Writing this letter is the least I could do for my brother in arms. I certainly wish I could do more because I know he would do all in his power for me. One irrevocable moment in life should not condemn us to the worst punishment. Dustin is not a violent man with a murderous intent. He was a shining example of patriotism, voluntarily standing proud to protect Americans' freedom in a time of war, until one disastrous moment, fueled by his confirmed wartime-related PTSD, caused him to do the unthinkable and lose his freedom. Thank you very much for your time, Your Honor. I wish you the best in life and decisions that weigh heavily on your shoulders. Respectfully, Devin R. Gomez.
Thank you.
Dear Judge Frizzell, thank you for taking the time to read this letter. My name is Timothy Duren, and I am the uncle of Dustin Duren, who is before you for sentencing. I write with full respect for this court and full awareness of the gravity of the offense. I am not attempting to diminish the seriousness of what occurred. Instead, I hope to provide insight into Dustin as a person beyond this tragic situation and to respectfully ask the court to consider some measure of leniency. I have known Dustin his entire life. Despite the circumstances that bring him before you, I have always known him to be someone capable of kindness, loyalty, and responsibility. What has stood out most throughout his difficult time is the deep remorse he has expressed. From every conversation, it is clear that he carries profound regret for his actions and the impact they have had on everyone involved. Since his arrest, Dustin has taken meaningful steps to address his behavior and rebuild himself in a healthier direction. He has engaged in counseling and has shown a genuine desire to understand the root of his actions and to take accountability for them. I believe these efforts reflect a sincere commitment to change. One of the most important parts of Dustin's life has always been his children. He loves them deeply and has remained dedicated to them even through this difficult period. I know that being separated from them has weighed heavily on him and has motivated him to better himself so that he can one day be the father they deserve. His children are young and still need their father's presence, guidance, and support in whatever capacity the court ultimately allows. Your Honor, I respectfully ask that you consider a sentence that recognizes Dustin's ability and his desire to continue the hard work of rehabilitation. I am not asking the court to overlook the seriousness of the offense, only to take into account his remorse, his efforts towards self-improvement, and the important role he still hopes to play in his children's lives. Thank you again for your time, your consideration, and your service to justice. Respectfully, Timothy Duren.
Thank you.
We're now going to ask a few of Dustin's friends.
All right, let's welcome in our guest for this hour. Joining us, former prosecutor and constitutional attorney KrisAnne Hall. KrisAnne, great to see you. Thank you so much for joining us here on the program. And I want to get your overall thoughts on the arguments being made here by the defense. But in particular, one of the things they're asking is to consider the children. Right? Now, he made them basically orphans at this point by committing this crime, but they're saying, look, give them the opportunity to have a father in their life in some meaningful way. Is that something under these circumstances the judge should consider?
Well, this is a very difficult case. Let us remember that there were no adult witnesses when this happened, and there's really no way for us to really know what happened in that room that day. And we know that the defendant had some serious problems, and this may be the most difficult burden that any judge has to carry. And this is why due process always includes this part, the testimony on behalf of the defendant and even on behalf of the victims. And we have to have judges that have wisdom and knowledge, but also a compassion that gives justice to the victims, but also understands the brokenness that brought everybody into this courtroom. And these are decisions that take long-term consequences, right? What do we do about this? I have to tell you, as a former prosecutor, I was always someone who wanted to really encourage the opportunity for recovery, for recidivism, and for someone to come into knowledge and love of their families. This is something that the whole family has to recover through. So the question about the children is very, very important. And the judge will have to consider, what will these children want in the future, and how can we know? And I think this is a very distinct case because we do have evidence that the defendant had PTSD and had his own brokenness problems that have to be taken into consideration.
But I have to say this. So, as letters of leniency, number one, I would argue the kids, when they're older, they could make a choice if they want to develop the relationship with the father. Just because he's in jail doesn't mean, or in prison, doesn't mean they couldn't choose to see him. So they could still see him. But number two, you know, for instance, Devin Gomez, his friend who was in the Marine Corps with him for 4 years, I believe, was shocked. He couldn't believe that he had done this. I'm not sure. Some of this shock and can't believe he did this, and one of the others said, he's an amazing father. Maybe he was at one time, but I don't know that the shock and what he used to be necessarily mean that he should get a lenient sentence.
I don't know that. I think there's a degree of leniency that that can be struck that still serves justice for the victims and takes into consideration the broken nature of the defendant. We talk all the time about how many defendants are often victims of drug abuse and victims of life circumstances that they don't have control over. In this case, PTSD, we still know very little about it. And because he is diagnosed, and because this is a situation that involved a trigger point, a possible trigger point for this PTSD, I think that that's something the judge really has to take into consideration. He needs rehabilitation. Now, I'm not arguing that he should serve a lesser sentence,
out of that character, I think you have to consider that.
I agree with you, and I think the judge is going to balance all of these things as we're kind of picking apart each side. The judge has a pretty big decision in this case. I think a tough one. Coming up next, we will bring you more from the sentencing hearing for convicted killer Dustin Duren.
Also ahead, folks, we're going to go back to Utah. Right now, the closed session is still underway in that motion hearing for Tyler Robinson. As soon as that's over and the judge allows cameras back in for other arguments, we're going to take you there live. Keep it here on Court TV.
Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, will safety concerns trump public access in the Charlie Kirk assassination case? We'll bring you the latest developments from today's big hearing.
Closing Arguments tonight at 8/7 Central, only on Court TV.
He's here. I saw him walk in. He's sitting in the back. Roadblocks.
It's kind of weird. Like it.
Kind of weird.
Yeah.
Yeah.
Sure.
All rise. Court of State of Utah is now session. The Honorable Tony F. Jr. presiding.
Please be seated. Court is now in session. Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff Hunt and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Good afternoon.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of media interveners also identified in the briefs.
Good afternoon, and I recognize Mr. Robinson in the courtroom as well. Good afternoon. And for the benefit of the record, calling case 251-403-576,
All right, looks like we're gonna get going here.
State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues. The first is the October 14th, 2025 audio recording of the closed hearing and the October 24th, 2025 transcript of that hearing. The second is the state's motion to amend or clarify the publicity order, commonly known or referred to as the gag order. And finally, the motion for limited intervention and request for notice of motions to close, seal, or reclassify, and which has been filed by the media organizations and by counsel who are present today. So as we begin, the first part is we'll begin by addressing the October 14th audio recording and the October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording the record should remain sealed. All members of the public and the press will be excused, and the hearing will not be broadcast. This is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties, or the public and the media, to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother, and we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
Too bad they don't get a stay.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning disclosure of what is discussed in closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it, I believe it is appropriate to treat all parties in the public equally, though I do recognize.
What does derogatory mean?
I know I've seen that before.
It's nothing to implicate. It's funny. But I assume it means nothing that would mean that they follow up further.
Security.
I'll identify one of the signs. Yeah.
You'll remember one day. What's that? Maybe the strategy.
For sure. I don't want to start talking about this. But I also want to make the assessment that is reflected. We will address that. And then just be.
Okay. 40-10.
You notice there, he sure didn't look too worried about anything, does he? Like I said, if you just got here, this is earlier, before they went on this closed hearing. They have not returned from the closed hearing, so we're just watching a replay of this. Then we're going to go back to Court TV to watch this other trial they got going until they come back live. Because these guys will be going into a closed session here just momentarily. Notice how chatty he looks, though. Kind of smiling, chatting. No, you know, no big deal. Okay, I'm looking at one of our other feeds. It looks like live session may be coming back here momentarily.
Please be seated. Court is now in session. Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff Hunt and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Good afternoon.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of media interveners also identified in the briefs.
Good afternoon, and I recognize Mr. Robinson in the courtroom as well. Good afternoon. And for the benefit of the record, calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues. The first is the October 14th, 2025 audio recording of the closed hearing and the October 24th, 2025 transcript of that hearing. The second is the state's motion to amend or clarify the publicity order, commonly known or referred to as the gag order. And finally, the motion for limited intervention and request for notice of motions to close, seal, or reclassify, and which has been filed by the media organizations and by counsel who are present today. So as we begin, the first part is we'll begin by addressing the October 14th audio recording and the October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording the record should remain sealed. All members of the public and the press will be excused, and the hearing will not be broadcast. This is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties, or the public and the media, to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother, and we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning disclosure of what is discussed in closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it, I believe it is appropriate to treat all parties in the public equally, though I do recognize.
What does derogatory mean?
I assume I've seen that before. I assume it means nothing implicates. Yeah, it's funny. But I assume it means nothing that would mean that they follow up further.
That's it.
That's mine.
I see.
I'll identify one that sent you.
Okay, that's it. And that's earlier. They go in their closed session, and now they're just getting ready to come back. So we're going to switch over to that real quick.
What's that?
And here we go live. Waiting on the judge to come back into the room.
Sure. I want to start talking about this. And I also want to make an assessment that is reflected. We will address that. And then just leave.
Okay. 40-10.
He's here. I saw him. Okay. He's sitting in the back. Roadblocks.
That's kind of weird. Like it.
Kind of weird.
Yeah.
Yeah.
Sure.
All rise. Court of State Utah is now session. The Honorable Tony F. Jr. presiding.
Please be seated.
All right, here we go, folks.
Court is now in session.
Court is
Counsel, if you
now
could
back
enter your
in
appearances,
session.
please.
Your Honor, Christopher Ballard, Ryan McBride,
See you like
Chad
and
Grunander,
share
and
the
Lauren
live.
Hunt
Everybody
on
share
behalf of
the
the state.
live and give it a
afternoon.
like, please.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser, on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff Hunt and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Good afternoon.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of media interveners also identified in the briefs.
Good afternoon. And I recognize Mr. Robinson in the courtroom as well. Good afternoon. And for the benefit of the record, calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues. The first is the October 14th, 2025 audio recording of the closed hearing and the October 24th, 2025 transcript of that hearing. The second is the state's motion to amend or clarify the publicity order, commonly known or referred to as the gag order.
Ridiculous.
And finally, the motion for limited intervention and request for notice of motions to close, seal, or reclassify, and which has been filed by the media organizations and by counsel who are present today. So as we begin, the first part is we'll begin by addressing the October 14th audio recording and the October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording the record should remain sealed. All members of the public and the press will be excused, and the hearing will not be broadcast. This is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties, or the public and the media, to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother, and we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly.
We're going back on the record in case 251-403-576, State of Utah versus Tyler James Robinson.
Disclosure.
I note the presence of counsel that previously entered their appearances. Thank you, Mr. Novak. We have come out of the closed session and they will be concluded that business. Is just given the nature and the sensitivity the court became aware I believe it is appropriate to treat an event that happened before the public equally, though I do recognize.
Exactly, Heather. Exactly. Not quite sure why he's.
And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel, and then I will make a ruling concerning that shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that the specific circumstances warrant it. It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is also our understanding that potentially some audio from counsel table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser. To the state.
Your Honor, the state, as stated earlier, we believe that the court's order was very clear, and if there has been a violation of that order, then we agree that there needs to be some measure taken we'll leave it to the court to decide the appropriate response to that violation. But we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard.
Oh,
To the
come
press,
on now.
attorneys for the press.
Your Honor, Jeff Hunt for the media interveners. This is the first time that we've heard about the violation. We've not had a video or investigate the audio or look at the capture of the computers, but filming of the inadvertent filming of the shackles, I did talk to the pool photographer. My understanding is that there was a zoom out shot that did filming of the show the shackles. The inadvertent filming of the shackles. I did talk to the pool photographer. My understanding is that there was a zoom out. They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information about that and whether that's a violation. Filming of the computers is not a violation of the decorum order. If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail the shot is that is of concern to the court. But I'll just say that we reiterated as soon as I heard this from Mr. Ballard with the pool representatives that this is very important to follow to the letter of the court's EMC order. They understand their obligations. They take that very seriously. They're not perfect. Mistakes happen. We're trying to correct as much as we can on that. But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter. The court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives, and we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream.
Please be seated.
As we restarted, so it's still a problem.
Thank you. Court is now in session. All parties weighing in on this important matter. And I find that there was a violation of the standing decorum order. Counsel, if you could enter your appearances, please. 30th, 2025, based off
Your Honor,
what's been
Christopher
proffered,
Ballard, Ryan McBride,
as well as the
Chad
EMC
Grunander,
order
and
signed
Lauren
by the
Hunt
court.
on behalf of the state.
As previously stated by Ms. Visser, the court
Good
does have
afternoon, Your Honor.
discretion
Kathy Nestor,
in
excuse
determining
me,
whether to
Richard
terminate
Novak, Stacey
the
Visser,
broadcast
on behalf
of these
Mr.
proceedings.
Robinson.
And again, if there's specific
Good
circumstances.
afternoon, Your Honor. Jeff Hunt
warrant
and David
such
Ryman
action,
appearing
that the
on
court
behalf
will
of the
make
media
findings
interveners
in
that
order
are
to do
identified
so.
in our motion papers.
I find that excluding the cameras from the courtroom would be disproportionate for this hearing. I find that making it very clear, first, that the transmission cannot begin until court is in session and must end as the court ends the session and cannot be filmed before or after. The filming of, as previously stated in the decorum order and EMC, must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place indicated by the bailiff, and then we will resume these court proceedings. I am anticipating this will take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward. We are trying to do the best we
shackles, even though he can dress in street clothing, has to wear shackles, but those shackles cannot be photographed or filmed in any way or videotaped in any way. Obviously, that did happen. He found that. There were some issues as to the computer for the defense, et cetera. I don't think he made a ruling on that, but he was clear, shot across the bow. I have the power to kick you out. If it happens again, that might be the remedy.
And I think he must have seen the video they've been talking about, because he indicated that it was on the computer, that they'd have to move the camera. Clearly, it must not have shown any of their privileged information. Let's bring in and get thoughts from a constitutional attorney, Chrisanne Hall. Chrisanne, weigh in on what we just heard.
No, I think the judge did the right thing. I really appreciated the fact that he said that removing the media would be disproportionate. I think that's the correct call. The shackles being in view is always a very important thing. When you have a defendant who is deemed to be unsafe to be released from shackles, in the courtroom, maybe some of our people watching have never been in a courtroom when that takes a case. When that happens, the defendant is actually, they make sure the defendant is brought in without the jury being present, and the jury can't see that the shackles are still on the defendant. All of this goes to cure and to eliminate any bias that might be created by the presence of the shackles. And it's interesting, like you said, that here we are already having a violation, but in my opinion, it's better that we get out these violations now and clear up any accidental, because the attorney for the media clearly said this is accidental. So if we clear up all the accidental exposures and violations now, then we can definitely make sure they don't happen.
Yeah, and Michael, clearly these things happen by accident. It's not a purposeful.
Yeah, and this is almost like a dry run. Let's figure it out now, as Chrisanne said. Hopefully it doesn't happen in the future.
That's right. Thank you so much, Chrisanne. We have to squeeze in a break, but more on that motions hearing for Tyler Robinson in Utah. Stay with us. We'll be right back.
Well, I am glad that the judge didn't shut it down right there. So. All right, start a little poll there while we wait for them to come back from this short recess. I was looking at another feed. They were moving things around in there, so we might have a different view when they come back, but we should be back soon.
Will love them. Subscribe and save 20%.
Guilty or not guilty?
Welcome back to Court TV Live. I'm Julia Janae along with Judge Ashley Wilcott. Thanks so much for following along with us as we are in a Utah courtroom right now. A hearing is underway for Tyler Robinson, the man accused of assassinating conservative activist Charlie Kirk last September. Kirk was shot and killed while attending an event in Utah Valley University. Now, Robinson ran off after the shooting, which prompted a massive manhunt.
He did surrender just one day later and now faces several charges, including aggravated murder. Today, Robinson made his first in-court appearance where the judge addressed several issues, including one about unsealing some audio and a transcript from a hearing that was held in October. Now, that particular issue was argued behind closed doors.
Now, court has resumed and our cameras are now allowed in as the judge hears other motions, including one for a gag order. So this is the pool camera that we are tapping into, not particularly our cameras, but let's get you inside of the courtroom for more of this coverage.
All right, let's move to the next matter before us. And of course, I'm looking for my notes, and they've disappeared. But that's okay. It happens. All right. Let's go ahead and address the state's motion to amend or clarify the publicity order. And I'll hear from all parties. And I know it has been briefed, and responses, but I'll hear brief argument, and then we can go from there. Mr. Ballard.
Thank you, Your Honor. With respect to this motion,
think as we've expressed in the past, everyone in this room shares the same goal, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once. The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that term just be limited to the prosecution team because that is the way that Rule 3.8 reads. Rule 3.8 of the Rules of Professional Conduct that deals specifically with requirements for prosecutors talks about investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor. So in other words, the prosecution team. And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses, and we think the court just means the prosecution team because if that term stretches beyond just the prosecution team, then the order as written we don't believe is a valid and lawful order because it would result in a prior restraint on certain speech and at the very least would have a chilling effect on that speech. If the prosecution agrees that we have an ethical duty to take reasonable measures to make sure that those who are identified with the prosecution team are alerted to the requirements of the court's order and to make sure that they do not make a statement that the prosecutors themselves would not be able to make, a public statement. But if the order extends beyond that, then we have concerns because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur. And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not itself justify a prior restraint. As the United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial. That's the high standard that applies in this case. And so in order to apply a prior restraint to persons beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis. The court would have to make a factual finding of necessity, that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures, and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored. And as the state has explained, the Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue in explaining the analysis that applies to various different people that might be associated with a criminal case. You have attorneys, that category of trial participants. Certainly the court has the highest degree of ability to be able to restrain the speech of attorneys, and in fact, as I've expressed, the ethical rules require that. But when it comes to trial participants, like witnesses, the standards are more demanding as far as restricting the speech of trial participants. And as the Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding. And I think the court also needs to note that there are several people associated with this case who have very significant interests in exercising their First Amendment rights in talking about how this case has affected them. And of course, can't say that one person's First Amendment right is more important than another person's, but there are certainly some people here who have a larger, some people involved who have a larger or a greater interest in speaking than others. And so I think the court needs to take that into consideration if this order is meant to apply beyond just the prosecution team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation for the state to be able to comply with that order, depending on how the court clarifies what witnesses mean. Does the court have any questions for the state?
No, thank you,
okay, thank you.
Ballard. Mr. Novak.
Thank you, Your Honor. I'm going to try to be brief because our views on the propriety of the court's order were set forth in a publicly filed document, which, of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public, and it's certainly not, I think as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we noted in our papers, is directed at the conduct of and the court's expectations for counsel. So even if, under that order that the court issued, somebody who we could all agree is a witness within the court's definition of that, made public statements which implicated Mr. Robinson's fair trial rights, the potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so. If I represented a witness who was accused of saying too much publicly, the first thing that I would tell this court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may, in the future, be some theoretical situation where the court issues orders that control the statements or conduct of specific people, but this, or other than counsel, but this order is directed at counsel. And we have no, meaning Mr. Robinson's defense counsel, have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term. So it is our view that the court's order is not overbroad, it's not vague, doesn't put the state or the state's attorneys in some untenable position. And I think it's a little too simple to say witnesses are either everybody under the sun or people who are under subpoena at the last second, because counsel have not only the training but a duty to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue, and maybe an attorney on either side of litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party. That doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers we refer to it as a potential lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants.
Already disagreements between the prosecution and the defense attorney in their legal arguments. We need to pause it there for a moment. When we come back, we will hear more of the argument to amend publicity order. Keep it here on your front row seat to justice.
The disappearance of Mother Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
Mr. Walsh was suspecting his wife of having an affair.
The massive trail of evidence.
This incredible timeline of Google searches.
It shows everything that was in his mind.
He searched how long before a body starts to smell.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Lawyers cannot make a statement that would violate Rule 3.6 and need to inform witnesses that they cannot make similar statements, and then requires the parties to inform lawyers, I'll just read it. Lawyers participating in the investigation or litigation of this case shall inform all witnesses, and then the list that I read, about the prohibitions contained in this order. So the order is prohibiting speech. And because if it extends beyond the prosecution team, it needs to have the findings that are required for that kind of prohibition on speech. That's what we're asking the court to do.
Thank you, Mr. Ballard.
Thank you.
All right. Let's turn to the final matter before this court, the motion for limited intervention and request for notice of motions to close, seal, or reclassify. And I'll hear from the parties on that.
Thank you, Your Honor. David Ryman, representing the news media. Mr. Judd and I represent different groups of clients, so I'm going to invite him, if I miss anything, to weigh in after I'm done. But my intent, the issues are basically the same, so my intent is to address them for all of the interveners at once, and I'll be very brief. We have only ever sought, in this case, limited party status. That is what we do in every high-profile case that involves these type of closure issues. We are not seeking to be parties for all purposes. We are just seeking to be parties for the purpose of showing up and being heard, which we unquestionably have a right to do. We unquestionably have standing. That is settled law in Utah. And the filing, the last filing at least, that we got from Mr. Robinson's team that just came in, I don't know if it was a couple days ago, basically gets there at the end where it says, look, if you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted to allow full party status under Rule 24 of the civil procedure rules in a criminal case, they said we don't need to do that. The woman in that case just needed limited party status. And so in a way, we're not really, the state really hasn't disagreed with this either, but we're not really disagreeing with Mr. Robinson's team. We have explained in our papers we've cited the court to extensive authority saying that this is the procedure to use. It's the most efficient procedure to use. Otherwise, I don't know what exactly the suggestion is for Mr. Robinson's team that we're supposed to do from here on out, but it kind of sounds like just this sort of ad hoc, show up anytime you happen to see something on the public docket that might affect the public's rights, and that's just not the orderly way that this typically happens. The other thing, as I've mentioned in our papers, that it does is it allows for the media to be able to take an appeal of a closure issue without having to rely on the court's extraordinary writ jurisdiction. And that was what they had to do in either Kearns Tribune or Bullock, where the media was not granted party status. And it is the situation that happened in FL, where they had to review her claim regarding records under extraordinary writ jurisdiction rather than invoking their appellate jurisdiction because she was improperly denied limited party status. So all of that authority supports the process that we are requesting in this case. We think it's the most orderly way to do it, and I'll end just by saying, there's been some discussion, and especially from Mr. Robinson's attorneys, about what rule it is that you need to do this under, whether Rule 24 applies. They seem to suggest that it doesn't. I will just point the court to two different rules that give you the authority to do what we're requesting aside from Rule 24. Rule 24 is in the civil procedure rules, but Rule 81, and particularly subsection F of that rule, says that the rules of civil procedure govern in criminal proceedings where they don't conflict with a rule of criminal procedure. That's the case with Rule 24. That's why courts in criminal cases have relied on that rule. The other one is Rule 31, and that's in the criminal procedure rules, and that gives this court the discretion, if it's not inconsistent with the rules, to fashion remedies and to deal with civil procedure, or not civil procedure, but rather just procedural matters. And so that is essentially what happened in the FL case, which is that, whether you do it under Rule 24, whether you do it as a judicially created, remedy, it doesn't matter. It's the same, it gets to the same place, which is just that we are interveners for the very limited purposes that we've set forth in our order. We're not going to be here at every hearing arguing, we didn't take a position on the gag order motion that you just heard. We are only planning to appear and argue so that the court has the benefit of someone who's representing the interests against closure. Because as you know, and this is sort of why we're here today, a lot of time this just happens by stipulation. Because these, the state and Mr. Robinson's lawyers, they may not want to fight over a particular issue. And so it really is a situation where no one really represents that interest. And the purpose of this whole process is to give the court the benefit of the briefing that we've submitted and the benefit of arguments to represent the public's right to attend these proceedings. So unless the court has any questions, that's all I have.
Thank you.
Thank you.
To the state, Mr. Ballard.
Your Honor, as the state briefed in briefing on a prior motion, I think it's clear that parties have outside entities have the ability to intervene in a case as a limited purpose party when there's a statute, a rule, or case law that authorizes them to take specific action in a proceeding. And there's well-established case law that allows the media to intervene, to be able to appear and be heard on matters of public access to court proceedings and to court documents. And Rule 4-202.04 of the Rules of Judicial Administration also make it clear that the media can appear and do just exactly what they've done in the closed session that we held earlier. So it doesn't make them a capital P party to the case, it makes them a limited purpose party, and they certainly have the right to be able to do that. Thank you.
Thank you, Mr. Mallett. Ms. Visser.
Thank you, Your Honor. So I just want to clarify, the issue really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case. And I think another part of that is what that means. And really that is what we are primarily concerned with. What does that mean? What does that enable them to do? What jurisdiction is this court exercising over them as a result of them being a limited purpose party? Because I do believe that is another aspect of asking to intervene in a case. I do think that Rule 24 does not apply here. I think that's what we learned from the Supreme Court. They don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad entry into a case for many purposes. In the instances where our courts have allowed intervention into civil cases, and I want to be very clear here, the case law is in the civil arena. There are very few instances where we're dealing with this in a criminal case on appeal. So we're a little bit in the dark, and we're asking this court to kind of wade through and make a decision that potentially hasn't been made before. But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it sounds to me like the media has somewhat conceded that their role in this case is under Rule 4-202.04, and their role is to have a voice regarding closure, which has already happened today and will surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice. We will follow the court's order. We have no problem with it. But we do want this court to make the procedure very crystal clear. We want time frames. We want orders saying this is when you need to respond, so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to. We're all attorneys. We all know that these things happen from time to time, and we're not unreasonable folks. If they reach out to us, we will grant reasonable requests for extension, just so everyone is aware. But there was no communication. So I want it very, very clear what they can and can't do. It's less about semantics. This isn't about semantics, it's about substance. What are they allowed to do? If this court wants to call them a limited purpose party, that has to be, well, it's so you can exercise your rights under 4-202.04. And in doing so, this is what you need to do. That's what we're asking the court to do. And I also have some practical concerns that maybe need to be addressed with the court's clerk. For example, are we adding all 23 media entities to the court docket? Will they have access to all of the filings? I have had instances in the past where, unfortunately, parties have been added to a case and still receive documents that are intended to be private or non-public. I'm very concerned about that. So I think it would be appropriate, if they are going to be added to the docket, that it be reasonable, perhaps just the two entities that are requesting, the two conglomerate entities that are requesting, and that there be an order from the court saying if they receive something that they shouldn't have, they notify us in the court immediately and they delete it, they don't review it. At a minimum, I think that's necessary. But I also think it would be reasonable for this court not to put them on the docket for that very same reason. So we don't think that they should have permanent status in this case. We don't dispute that they are going to be here. They're already here, as we well know. But we do think how that happens is important, and that this court should exercise its authority to make very clear what everyone's roles are here. And as I believe they put in their briefing, that they are neutral observers. Neutral observers. We don't want the chaos that is out in the media in this courtroom. So whatever this court can do to prevent that is what we're asking. Does the court have any questions for me?
No, thank you.
Thank you.
All right, counsel.
Thank you, Your Honor. Just very briefly, I'm not sure what neutral observer is supposed to mean. We have interests in the case. We are here to advocate for openness and against closure. And so I don't think that's what counsel meant to imply, but that's the whole reason we're here, is that no one else represents our interests. That is straight down the middle of what the intervention rule requires. Just a couple clarifications. Counsel said we haven't cited any criminal cases where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is the procedure that judges routinely follow, including judges in this building. Counsel said that our role is strictly limited to advocating for what is under Rule 4202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings. And that rule does not technically apply to proceedings, it just applies to records. So just to be clear, but I think we have been clear, and this is all, I mean, there wasn't a whole lot of daylight between what counsel was just suggesting our role should be and what we've asked for, you know, which is just if they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with the motion to disqualify. They were able to at least provide that to us. It's not very hard to send an email. That's all that we've asked for in terms of the notice. And then we have the right to be heard on those issues. And so I didn't really hear from counsel any reason why we should not be granted limited party status in this case, other than just some sort of, you know, confusion on their part as to what that would actually look like. I don't know how the clerk deals with parties on the docket. I assume you guys can sort that out. Typically, when we intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, you know, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what it is that we are asking to do. Just one last point on, well, 2 things. One is that counsel's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to Your Honor with an order, you know, which they just assumed you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical, like, deadline where we were invited to weigh in and just didn't. Last thing is, in terms of docket access, you know, Mr. Hunt and Mr. Judd and I are all officers of the court. If the court says you can have access to things that the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. Some judges do handle it that way. Sometimes we just, you know, if they don't concern closure, sometimes we don't weigh in at all. But, you know, when they file things that they say we need to file this under seal and we're not allowed to see it, then the briefing for you is not super helpful, you know. And so typically the way this happens is we are allowed attorney's eyes only access to, you know, documents just like the state and the defendants would be. Their counsel can see things that are non-public, and we don't share them with our clients unless the court orders otherwise. And typically, if the court decides, no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are non-public, that's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if there's a procedure where we can see them so that we can give the court the benefit of briefing substantively as to what it is, then we keep them attorney's eyes only until the court orders otherwise. And that's just typically the way this works. So, thank you.
All right. Anything further?
Your Honor, I'm not going to belabor what's already in the briefing. I do think it's concerning to just cite to a bunch of trial court cases without providing any pleadings or context for what occurred in those cases. I can't argue against what happened in other cases. This is our case. Our case is different. This court has already acknowledged it. There are many interests. We have concerns about leaks, information getting out that shouldn't be out. I think those are valid. And our concern is access. I'm not impugning the integrity of these gentlemen. I'm sure they would act as officers of the court. But the more this court controls the information that ultimately it determines to be private, the more able we are to identify if there are leaks, if there's information that's getting out that shouldn't be, and who did it. So we are objecting to providing the media our pleadings in advance, even just to their counsel. We don't think that's appropriate. I don't see any authority for that. We're asking the court not to consider that. And we're concerned about opening the door to multiple other entities just filing in on this case, getting involved in the proceedings. We don't know exactly what media means either. So our position is and remains, they can file what this court has authorized to file in the manner this court authorizes to file it and be heard in the manner this court indicates. We understand they're entitled to closure hearings, and I did make a mistake. We agree that they have standing to object to closure as well. So they should be able to file those things, but we do not agree that that requires status in our case. So, does the court have any questions?
No, thank you.
Thank you.
All right. I appreciate the argument from all parties throughout this day. I wish to commend the preparation and the quality of the arguments, as well as the civility that is sometimes overlooked, but I wish to recognize that and appreciate counsel's demeanor and their arguments today. I previously stated when we began that I would be issuing rulings on the first issue, and when I began, I initially said October 14th. It's actually the October 24th audio recording of the closed hearing, as well as the October 24th transcript of that hearing. And so I wanted to create, just make that small correction. But given the in-depth and necessary arguments made in the closed hearing, I wish to take the time to issue a ruling that will say what will be disclosed and what will be kept private, because this court has a duty to do so. And I would rather do it right and take more time than to be rash and miss the mark. I need to be narrow in my approach, and it is an important issue, and so I plan to do that. In regards to the motion for limited intervention and request for notice of motions to close, seal, or reclassify, I also wish to craft my order in such a way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that ruling at the same time. And so I will be issuing the ruling in regards to the state's motion to clarify court's pretrial and trial publicity order, and I am prepared to do so. Before I do that, what I want to do is, and counsel is being caught off guard because they were anticipating a ruling today, but what the court is intending to do is, and proposing to the parties, is issuing an oral ruling on WebEx that all parties can attend to. The reason why is I don't want to take a lot of time. These are important issues. I don't want to wait until January 16th. And I want to talk about potential dates. I don't imagine it will take longer than 20 minutes for this court to issue ruling. And I want to get the parties' input in regards to their thoughts of the court issuing an oral ruling on WebEx. And so I'll open it up to the parties.
We don't have any objection to that, Your Honor.
Thank you.
We have no objection to that, Your Honor.
Yeah, same.
All right. Well, next comes the trickier part when you have a room full of attorneys trying to find a date that we're all available. To our staff, what dates do we have available for a 30-minute block before the end of the year?
Judge, we do have December 29th at 10 o'clock.
How does that appear? How does that date work for counsel?
That was 10 a.m. on the 29th?
Yes.
Your Honor, that works for Mr. Robinson. Thank you.
Same for us.
All right. And to defense, in regards to Mr. Robinson, what is your position on, if it is on WebEx, he would be appearing by WebEx, or is there different thoughts?
Your Honor, if we could just have audio only for Mr. Robinson to appear, since we will not be present, I would rather not have him in the courtroom without counsel present.
All right. Thank you. I appreciate that. So we will set the court's ruling on those two issues for December 29th at 10 a.m. And a note that it will be audio only for Mr. Robinson per defense's request. And to the last issue is, well, before I issue my ruling, I anticipate, and counsel, are we still on the same page in regards to our January 16th hearing? Are we planning for that?
Your Honor, we are. We believe that most likely what we would anticipate doing is on January 16th, arguing our motion to disqualify the county attorney's office, which was just filed. That should give them enough time to respond to that. And also possibly, we anticipate filing our own motion about the pretrial publicity order that has a little bit different take on it. That should be filed in plenty of time for us to argue that on the 16th as well. I think we have set aside the 30th, and that might be the one we want to save to argue our anticipated motion that's coming about keeping cameras out of the courtroom. And we will, I imagine the media will, depending on the court's ruling today, will want to weigh in on that one as well, and that would give them enough time as well. So that would be January 30th.
All right, and before I go to the other parties, the January 30th date, there was some complications, and so we have to find another date.
Okay.
And so I just wanted to let all parties know before we lock in our schedules, what dates do we have available for a 4-hour setting?
It's okay. My problem.
And counsel, I appreciate you giving me that roadmap that helps plan, so it allows the other parties to take in consideration dates and filings as well. So as staff is doing that, they are looking for hearing dates, and one of the complications is, as a judge, I have 1,409 cases as of last Friday, and so trying to find a spot is tricky, and I'm grateful for my staff who work so hard to manage that calendar. So that is part of the reason for the delay, and we're trying to find a date because this is an important case, as is all of those cases. They matter to me.
Your Honor, while we're waiting, can I, if I might just make one point that might make things smoother as we go forward with the sealed filings? Just to Ms. Nestor's point, Mr. Novak earlier mentioned something about a redacted motion to disqualify, and I don't know if that is something that they're planning to file, but I was just going to say, sometimes, you know, what we heard earlier about that particular incident is probably not something that we care that much about in terms of what they would redact. And so instead of opposing the motion to classify, if Your Honor, I don't know if this is the plan already in this case or whether that's what they were planning to do, but if they file a redacted version that, you know, just takes out the stuff they care about rather than closing the whole thing, then we don't have to say anything and probably avoids, you know, fighting over unsealing that document. So I just wanted to say that. I'm happy to confer with counsel if you'd rather us do that, if you don't want to do it by way of a court order. But
No, I appreciate that input. I'll hear from both parties, and then we'll get to the date.
Your Honor, I do anticipate going through and seeing what we can redact and working with the state on that as well, and with media counsel, so.
All right.
And we agree that filing a redacted version is a good way to go. We can work together on that. As far as the January 16th hearing, the state will do everything it can to respond to these motions as timely as we can, as expeditiously as we can. I just want to note that that January 16th hearing was set with the expectation, the previous expectation was that defense counsel was going to get us these motions before Thanksgiving. And we just got the motion to disqualify last night. So we'll do everything we can to respond to those as expeditiously as we can and hopefully keep that date, but I'm not guaranteeing that we'll make that date.
All right. I appreciate the heads up. Going to staff, what dates do we have available for in lieu of the 30th? February 3rd, morning or afternoon setting?
Your plan? Mm-hmm. That works for Mr. Robinson, Your Honor.
All right, thank you. And morning or afternoon setting?
Either works for us, Your Honor.
All right.
As well as for the state, we're available on the 3rd.
The afternoon would be better because it may be that it reduces travel time.
All right. Well, it is always nice when all parties agree. So we have February 3rd at 1 p.m. It is anticipated to be in person. And Ms. Nestor, is Mr. Robinson planning on appearing?
Yes, Your Honor.
All right. Thank you. All right, that concludes that particular issue about future dates, and I appreciate counsel working with me on that. We have December 29th at 10 a.m. for the court ruling on these two issues, and that will be via WebEx. And then February 3rd, January 16th, I believe that is at 1 o'clock. Is that correct? All right, that's in person as well with, I believe, defense has indicated Mr. Robinson will be present as well. And finally, February 3rd at 1 p.m., and also indicating that Mr. Robinson will be present. And in regards to the final issue, the ruling on the state's motion to clarify court's pretrial and trial publicity order. This is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6 To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts that there are over 3,000 lay witnesses of the alleged homicide. The state does not know if it must inform each potential witness or each potential and possible witness of the prohibitions in order, or whether the order applies only to witnesses who are members of the attorney's teams, such as investigators or experts. Due to the potential confusion, this court grants the state's motion and offers the following clarification. The word witness, as used in this order, applies to all witnesses who are part of the prosecution and defense teams. This includes any witness, including lay witnesses, whom the prosecution or defense has a good faith belief will be called to testify at a hearing or trial. The court also clarifies that the publicity order as written regulates the behavior of attorneys who are associated with the defense team or the Utah County Attorney's Office. It requires the attorneys to abide by Rule 3.6 and, in order to deter non-attorneys from making prejudicial statements, requires the attorneys to inform witnesses about the prohibitions in the publicity order. Informing witnesses about the prohibitions in the publicity order is a necessary step. It is one moment as I regain my place as I read. Informing witnesses about the prohibitions in the publicity order is a necessary step toward not intentionally, knowingly, or recklessly permitting witnesses from making prejudicial statements. The publicity order does not regulate the behavior of any person who is not an attorney associated with this case. And this order will be signed today by myself and made public. Counsel, is there anything further that we need to address today?
Thanks, Your Honor. Yes, just the matter of having Mrs. Erica Kirk designated as the victim representative in this case. She has filed through her counsel a request to be designated as the victim representative, and we would like the court to formally acknowledge that request and formally designate her as the victim representative. And I guess along those lines, I wanted to make clear as well, I think this court stated earlier that there was an alleged victim in this case. And I know that there is case law talking about being careful about how we refer to victims and alleged victims. But in this case, that case law makes clear that those cautions don't apply with the same degree, where it's clear that we have a victim who was killed in this case. We don't have an alleged victim. We have an alleged perpetrator, but we do know that we have a victim in this case.
Thank you, Mr. Ballard. I'll hear from the parties.
Your Honor, on behalf of Mr. Robinson, we certainly think it's appropriate for Mrs. Kirk to be designated as the victim representative, if that is the desire of the state, just so there can be no doubt that she's afforded all of the rights assured to her under our state statutes, and we have no objection to that.
Thank you. Thank you to all parties. This court will recognize Ms. Erica Kirk as the designated victim representative in this case. Thank you. Counsel, I believe that concludes our matters for the day.
One more
or maybe
matter,
not.
Judge. I can take the podium, Judge?
Yes, Mr. Gernander.
The purpose, I want to just give the court an update with respect to discovery. We've done that at previous hearings.
I appreciate that.
The state has received approximately 13,900 files from law enforcement in this case. Approximately 300 of those we believe are duplicates. We have since provided to council, as of, I believe, this morning, 7,951 of those files. For the court's information, we had reached close to 100% had been disseminated as of last week, but we received quite a large batch within the last few days. So we were working on that. We still have a full-time paralegal that's dedicated to reviewing that, organizing it, Bates stamping it, and sending it out to council. Of course, there are necessary redactions that are being made along the way. Our next real hearing in this case, second matter, our next real hearing in this case is not scheduled till January 16th. We understand the court's caseload. We understand the difficulty of finding dates for a preliminary hearing. And we would like to make a request that the court calendar a preliminary hearing in this case.
All right. In regards to, and I appreciate the heads up and acknowledging the busy calendar of not only the court, but all of you, what, first of all, how many days does the state anticipate, which helps us in our calendaring efforts?
Judge, given that it's a probable cause standard, and all the inferences go in favor of the state is asking for 3 days. We believe that we can present the evidence required to meet that standard, and that would also allow the defense to cross-examine witnesses and argue that standard.
Thank you, Mr. Gernander. Turning to defense, what are your thoughts?
Your Honor, we were not aware that he was going to make that request today. We do have one more member of our team that's not present that we would need to consult with. I don't know when he's talking about, but I don't see how we can set it until all the discovery has been received. And also, we do need to deal with the disqualification motion, just in case. So it doesn't seem like a good idea to set it before we have the disqualification hearing. We were only talking about a month from now. I think that should probably be resolved before we set any dates. But I am concerned about setting a date when we still don't have all the discovery materials. We have significant discovery materials that have not been received yet, that we know are out there and coming and important. And we have to, have time to review it all and absorb it all. And I am going to be involved in another trial that is not over until the end of March. So that's going to take away my ability to work and process through discovery and communicate with our team. So it seems to me that with the understanding of what Mr. Gernander's trying to accomplish, that maybe we come to the hearing on the 16th with an idea about, we can have some conversations with Mr. McBride and also with the paralegal that's dealing with all the discovery and see realistically when we think we're actually going to have the vast majority of the discovery materials to us and how long it's going to take us to review it all. So maybe we could just come prepared in about a month to try to accomplish that.
Mr. Gernander.
Just 2 points, Judge. Sometimes I feel like we as practitioners sometimes lose sight of the purpose of a preliminary hearing. It is a probable cause determination. The primary purpose, according to case law, is to ferret out improvident prosecutions. So again, it's a probable cause standard. We are working as hard as we can, being very diligent with respect to collecting and disseminating discovery. Rule 16, subsection 2, speaks to the timing of mandatory disclosures. And it is it's a continuing duty. So as far as complete discovery being provided, in a case like this, complete discovery is going to be ongoing until probably trial. There are times when things become available during trial that are discovered to opposing counsel. But it says here, the prosecutor's disclosures must be made as soon as practicable following the filing of an information, except that a prosecutor must disclose all evidence that the prosecutor relied upon to file the information within 5 days after the day on which the prosecutor receives a request for discovery from the defendant. That's been accomplished. It then says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary hearing. So we are in the process of that, collecting it as quickly as possible, making any necessary redactions, and moving it to the defense as quickly as possible. But complete discovery is not required before a preliminary hearing. we have to provide it as quickly as possible. We have that duty, and we continue to do that. So we think we can schedule a preliminary hearing and work towards that. I'm aware of Ms. Nestor's schedule. I know she's going to be in trial, I think, in February and March. And I'm probably overestimating the availability of the court's calendar, but the hope would be sometime in April to schedule a preliminary hearing.
All right.
I'll submit it, Judge.
Thank you.
Your Honor, can I just clarify one thing? I mean, the county attorney has made a decision, very public decision, to announce their intent to seek death the day that there was an arrest, which means that that obligation to provide us with the probable cause for everything they relied upon to charge applies now to their intent to seek death. And we're nowhere near getting that material. So that was their decision to release that. Normally, that decision is not made until 30 days after a preliminary hearing. They made it in advance, and now they've got an obligation to tell me their aggravation and what they've relied on to make this a death penalty case. And we have not received that. So I'm waiting, but I'm just laying that out there for now.
Thank you. I appreciate the arguments from all sides. I do not find there is any prejudice in setting a date for a preliminary hearing. It is not set in stone, and it certainly can be moved. I recognize that the parties have a lot of obligations, but I also recognize the importance of this case moving forward, and if nothing more, then this is a goal for the preliminary hearing. If it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and criminal dockets. What is a date that we may have available for a 3-day setting for a preliminary hearing?
Judge, the first week that we would have available is the week of May 18th. We do also have a week of some days in June we could accommodate. We do not have any in July. We have some in August.
All right, let's take a look. So, counsel, well, what dates in June?
June starting on the 15th.
All right. Counsel, I'll turn to you. Again, this is a goal. This is not a date that if we can't meet, there's any prejudice that will be attached to a party. In regards to May 18th, how does that tentatively look for counsel?
May or June?
May 18th is the first date, I believe.
Oh.
18th, 19th, and 21st.
So 18th, 19th, and 21st, just to give you the full range.
The state can make those days work, Your Honor.
Okay, perfect. Your Honor, we have availability the May 18th with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
All right, thank you. So May 18th, May 19th, and May 21st. And it will be in person, and do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right, thank you. I just want to put that on the record as well. All right, I don't want to be presumptive, but is there anything else? All right. Counsel, thank you again for your hard work today, and I wish you all, Mr. Robinson, a good afternoon. Court is in recess.
Thank you, Your Honor. Thank you.
All right.